and I'm excited to have you join us again for PPL422 Landlord 2. Remember, Landlord 1, we majored on customary land tenure. Landlord 2, we are now looking at the Land Use Act and other statutes that guide land law in Nigeria. And of course, we have had some topics and I hope you have found them interesting. So today we are treating another topic that will enrich your knowledge on land law and prepare you, to practice well as lawyers in this very interesting and rewarding field. So let's not waste time. Let's go on and see what we have for today. So this is our seventh lesson, and in this lesson we'll be learning about recovery of premises. At the end of the lesson, we should be able to explain when we can say premises are used for residential purposes, the mode of termination of tenancy, the essentials of a valid notice to quit, the length of notice required for recovery of premises, and the definition of main profit. So, the mode of recovery of premises will depend on the nature of the use for which the premises is put. If the premises are used as, for commercial purpose, then a different law will apply from where premises are used for residential purpose. Please note that where premises are used for commercial purpose, it will not be assumed to be residential. It will be assumed to be commercial. So, for instance, if a residential premises is used as a guest house, the occupants are called lodgers. They are not tenants, and recovery will be under a different rule. Whereas if the premises is used for residential purpose, the occupants are called tenants, and then for recovery, the premises regulated by the recovery of residential premises law of the different states. There are different laws. Each state has its own law. So, the main mode of termination of a tenancy is by the issuance of a valid notice to quit. Please note, not just a notice to quit, but a valid one. And the notice to quit, of course, must be in writing. So, whilst people allow it, a verbal notice is not deemed to be valid. And the effect of the notice not being valid is that it's of no effect. So a defective notice has no effect in law. It's not sufficient to terminate the tenancy. And the result will be that any claim made on the basis of a defective notice is liable to be struck out by the court. On that point, you can see the case of Eleja and Bangudu. So to your first activity, what is the usual mode of terminating a tenancy? Think about it. Let's move on to the essentials of a valid notice to quit. Remember, we talked about the effect of a defective notice. So when can we say a notice to quit is valid? First is that it must bear the name, it must be written in the name or sent in the name of the landlord or his authorized agent. Where an authorized agent is the one writing the notice to quit, he must state expressly the capacity in which he's writing, that is, as the agent of the landlord. The name of the tenant must be expressly stated. The nature of the tenancy, whether it is weekly, monthly, yearly, must also be expressly stated, because there are implications as to length of notice and all of that, notice period. There must be a brief description of the premises that is subject of the tenancy. The effective date of the notice to quit must be expressly stated, and the date when delivery of possession is expected. So when we say time for delivery, we are not talking of 12 o'clock, 1 o'clock, 2 o'clock, that kind of thing. We are saying by a particular day, right? Now, the notice must also be clear and unequivocal as to the true intention of the landlord. It must be clear Now, what the landlord is trying to do is to terminate the tenancy. And then the landlord does not have to state why he's issuing the notice to quit. People do that, but it's not necessary. As to the length of notice required, first of all, parties are bound by whatever they have agreed. Then, alternatively, where nothing, parties have not come to an agreement, then the length of notice will be taken to be a week's notice for a weekly tenancy, a month's notice for a monthly tenancy, and a 6 months notice for a yearly tenancy. Going back to what I said about parties being bound by what they have agreed, please note that it will be inequitable to get a tenant for a landlord, to get a tenant to agree to shorter notice than the prescription of the law. It will be inequitable and may be viewed as an expression of bad faith. Okay, so to main profit. Now, main profit presupposes that a notice to quit has been handed to the tenant, the notice has expired, and the tenant is expected to have delivered up possession to the landlord, but he hasn't done that. That's when the landlord can claim main profit. So main profit is defined as a compensation payable by the tenant holding over. Remember what we said, he's a tenant holding over. He's no longer just simply a tenant, for the use and occupation of the landlord's premises after the expiration of the notice to quit without delivery of possession by the tenant. As we said, the tenant has exceeded his term, notice has expired, the time within which he was expected to leave has passed, but he hasn't left. From that point on, the landlord will be entitled to main profit. Main profit is similar to damages payable to a landowner by a trespasser, because in actual fact, from that point, the tenant is actually a trespasser, but you don't use that term, a landlord and tenant. Same thing, you don't use damages, so you use main profit. And it is usually assessed by the court. It's the court that will determine how much should be payable as main profit. And in determining this, the court is not usually, minded to value main profit as the same as the value of rent payable for the property. So, to your second activity before we bring this lesson to a close, I want you to tell me what we mean by main profit and why it is necessary. So we have come to the end of this lesson, where you have learned when premises are said to be used for residential purpose, the mode of termination of tenancy and the essentials of a valid to quit, the length of notice required for recovery of premises depending on the time, the length of the tenancy as well, and the meaning of main profit. You can always download the video and watch it again and again to deepen your knowledge. But if you have any questions, then please feel free to send it to the discussion forum, and then we can discuss it and make it clearer. So until our next class, thank you for taking part and take care.